being a part and just your loyalty to AOA. We really appreciate it. Super excited about our meeting today. It's going to be the 2025 legislative update, and this will be comprehensive. And, our goal, as always, is to help you make and or keep more money than ever before. And so this is definitely going to be one of those live streams you're not going to want to miss. And, just before we get started, I want to say it is 2025. Please, please, please use the AOA lease that is freshly done. It's the version that you need for this year. And well, you may ask, well, what's in the new one? And I can tell you what's in the new one. There's a section on the micro mobility devices that's in there, that's included, that wasn't in there before. It includes a section for the rent reporting addendum for those to fit in. We have two different addendums for that. There's one for Section 8 and one for non-Section 8. And so that's part of the update that you're going to get later today. SB 611 went into effect, and so we struck out the $50 charge for serving a 3-day notice. And so you want to make sure that you're not charging that one anymore. That's in there. We changed the word pets all over the place to animals to align with our wonderful animal addendum instead of pet addendum. Animal covers both pets and animals. And our speaker today had a massive, massive influence in and feedback into that addendum. And really, it's almost his, basically. But anyway, so thankful for him. We updated just the whole checklist of addenda that are in there to include things that are more updated, including utilities if you're doing rubs, and even an empty box. We struck verbiage on the page about becoming a month-to-month lease, and that's only for our single-family condo owners, and it allows them to give notice to not renew tenancy in most areas. So that's cool. And then we also have a section on condominiums. It incorporates the governing documents of the condominium or the tenancy in common, including the clause in the rental agreement. So it provides you several layers of protection for condo owners. There's more than that, but those are just quickly things that are new in the lease. You want a relevant lease. Don't use the old one. I know it's easier, or use anything that's old. And so again, we're here to keep you in the know. And remember, what you don't know may cost you a fortune. And for some of you, it may be your very first time watching us. And we do have a money back guarantee. If you become a member, it's $97 for the year, and you will give you your money back if you don't feel like it's worth it. There is so much going on. We have next Tuesday. Normally we do these live streams on Thursdays. This week and next week we have these live streams, but next week it's top tax strategies for real estate investors. So very specific. And we also have the resident manager update. So that's going to include the 2025 California wages, hour, and rent law. And then we have a bunch of in-person seminars coming up as well. We have double headers, one on the west side, Wilshire area. We have one in Buena Park, one in Long Beach. In February, we have a double header in San Diego. And in February 19th, we have the Bay Area Landlording Power Conference. And so if you're up in that area, you're not going to want to miss that. There's going to be 7 different speakers. We already have 20 some odd vendors that are going to be there. And that's going up and up. So that's going to be a great event just to meet some new vendors as well as network and everything else. And so if you're watching on the AOAUSA.com channel right now, like there's a blue help button and you can type your questions in there. But also at the very top, there's a little YouTube icon. So after the fact, you can always watch these just by going to the YouTube channel. And sometimes we do this like a hybrid where part of it's Zoom and part of it is on YouTube. Not today though. We just had a power outage. And so we're using hotspots and improvising right now, but we're going to just get into it. Our speaker today has been in the industry for over 25 years. And 16 or 17 of those, probably now, since we're in 2025, it's 17 years as an attorney. And he's the president and founder of Brennan Law Firm, and he does landlord tenant litigation and evictions. He writes articles, he participates in seminars, and really those seminars that I mentioned, he's going to be present at those, most of those anyway. And he does a $1 million trade show, super active in the landlord tenant industry. And he really has inside access to a lot of things that are going on. There's legislative committees that he's a part of where he reviews and interprets proposed laws. So that helps us get in early to understand what's happening and try to advocate, hopefully. And he's been a landlord himself, so he knows your pain. So it's really a great pleasure to introduce Michael Brennan to you. So, Mike, thank you so much.
Thank you, Jeff. I appreciate it. Good morning. Okay, so we have a tremendous amount to cover today, Jeff. I'm going to start off with a couple preambles, and then I'm going to share my screen and let everybody move along with me so they see exactly what I'm looking at. As Jeff stated, my name is Mike Brennan. I've been doing this, it's actually 18 years. As a licensed attorney, I was doing it before I was a licensed attorney as well. We've been in the rental business for a long, long time now. And so, as Jeff said, I really understand what the landlords are going through. First, I'd like to mention that I will provide these slides to AOA. So anybody who has questions about them afterwards, you can just contact AOA and they'll be happy to send them off to you. And second, I want to remind everybody, like I said, we've got a tremendous amount to cover today. And I am a human being. It may be that I misspeak about something. I'm not here to provide any sort of legal advice today. What I'm providing you is information on the laws that are going into effect, that have been contemplated over the last legislative session. We'll talk about some laws, we'll talk about ordinances, we'll talk about trends, but none of it's legal advice. If you have a specific situation, before you assume that something I say today applies to that situation, contact a competent attorney who knows what they're doing in this industry, and discuss it with them. Like I said, we have a tremendous amount of ground to cover today. A lot took place in 2024 and 2025. I was really surprised when I started putting this seminar together, how much really occurred over the last year alone. And so please be patient. I'm going to be talking very, very fast. The last thing I say is for any questions that you pose to AOA, I won't be able to answer all of the questions today, obviously, because we are limited on time. But for those that I can get to, please remember to put the city that your property is in, and remember to put the year it was built, because both of those have an impact on my response. If you don't provide that information, that's okay too, but I'll be limited to giving a very generic answer to that. So with that said, let's jump into this. I have got to share my screen with you guys real quick, so let's do that. And I'm going to disappear for probably a couple hours now. All right, so like Jeff said, this is the new laws. Jeff, I just need some confirmation that you guys are seeing the whole screen is just new laws and emerging trends 2024-25.
Yeah, yes. So I can see that, and our guys are good, and you're down in the corner, so they can see you in a little box.
Okay, perfect. So let's jump right into this. New laws and emerging trends. Let's start with an overview of the topics. First, we're going to talk about some legislation that we won. That is important. It's key that you remember that we do win when we fight hard, believe me. We'll start there, and then we're going to move into some bills that were passed into law, and we'll do that by category. We'll start with some general landlord tenant laws. We'll cover fair housing, affordable housing. We'll talk about some building and health and safety laws that have been passed that will impact at least a few people on here, if not many. And then we're going to jump into a miscellaneous laws side of it. And then from there, we're going to talk about the expanding and emerging trends. And specifically, what I want to address today is the increased landlord obligations. There's a tremendous amount of red tape, hurdles, hoops, whatever you want to call it, that just since COVID, there's been a tremendous amount that has changed, and more obligations coming. And with obligations, obviously come liabilities, and then potential penalties for failures to comply with that stuff. So we'll go through that, and that is a long list. We'll talk about some rent control, some just cause and tenant protections that were passed, a long list. We'll talk about right to counsel, and that went into effect as of January 1st, what that means for people in certain areas. And then we're going to talk about the Violence Against Women's Act, and I'm going to bring that up because it has recently become an affirmative defense. It's been on the books for a while. The vast majority of landlords I know have not complied with it and are not complying with it, and it's going to lead to losing evictions. So we'll talk about that as well. And then we'll jump into some pitfalls to avoid and strategies for success. So let's jump right in. Let's talk about what we won. First, we won Prop 33. That's a huge victory. Obviously, Michael Weinstein's third attempt at rent control. I don't want to call it statewide rent control. It would have been state mandated that each city has the right to implement rent control. But it was his third attempt, and it's the third time we've beat him. I will caution everybody, because look what happened the last time we beat him. The state turned around and implemented statewide rent control because the legislators thought it was going to pass and it didn't, and that was somewhat of a retaliatory move. But essentially, it would have repealed Costa-Hawkins, and there's a lot of rights. I don't have the time to go into everything about Costa-Hawkins, but it would have repealed Costa-Hawkins and the rights that come with it. And it would have permitted rent and vacancy control on every single rental unit in California, potentially, if the cities enacted it. It was defeated with a 60% split, meaning 60% of the California population voted no. That's a huge split. And I have a question posed there. Will California respond? I'm not sure. We'll see. If last year is any indication, or the last time we won is any indication, they probably will. They'll probably tighten up the Tenant Protection Act, but we'll deal with that when it comes. And then the second piece of legislation that I call a win is balcony inspections. The inspection due date was extended to December 31st, 2025. So you guys have another year. Those of you who have to have the inspections done have another year to get that done. And they added civil engineers to the acceptable list of inspectors. So those are the two pieces of legislation that we won on. I would like to thank everybody on the Prop 33 win. That took a tremendous amount of coordinated effort. Each time it's taken the same thing. Not only was it a tremendous amount of coordinated effort, but it was also a tremendous amount of money that went into this. And at every seminar or webinar I did last year, virtually everyone, I said, I'm not a guy who goes out asking people to donate, but for this proposition, I am. And everybody stepped up and really donated and worked together to defeat it. So congratulations on that. All right. So having said all that, let's jump into general landlord tenant laws now. What laws have changed or are going into effect? And like I said, there's a lot of them. So let's jump right in. All right, AB 2493, screening fees, screening policies, and credit reports. So a lot of changes here in this one law. First, let's talk about the prohibitions on screening fees. Landlords are now prohibited from charging screening fees in two situations. One, if they know or should have known that no unit is available now or within a reasonable amount of time. So from my perspective, unless you have notice that somebody is going to be vacating, anything beyond that would not count as within a reasonable time. So unless you've got notice or you've got a vacancy, don't take screening fees from people. It would be a violation of the new law. And then second, it goes into this mandatory screening policies. So the new law sets out two options landlords can choose, or one option between two choices. Option one is a landlord can only charge application fees when the applicants are provided written rental criteria together with the application. A lot of you guys already do that, so that's not a big deal. But they also have to process the applications on a first come, first qualified basis and take the first person who qualifies. Now that has always been a misunderstanding in the industry for decades. People have been told, oh, you have to number your applications and take the first person who qualifies. And I've always said that's a myth. It's not true. There's no case law on that. Fair housing promotes that, but it's not true. You have an obligation to take the best qualified person. And the state is trying to limit that opportunity for you. So again, option one, you can charge application fees if you're going to provide your written rental criteria, and you're going to choose your applicant based on the first person who qualifies. Option number two, you don't have to take option one. Option number two is you're not required to accept the first qualified applicant, provided you return the fee to any applicant who wasn't selected within the lesser of either 7 days after the tenant was selected, whoever you selected, or 30 days. So in other words, if you go 30 days without, and let's say you received 5 applications and you go 30 days and you haven't accepted it from anybody, or you haven't accepted any applicant as a tenant, you would have to return all of those fees unless you are willing to operate on a first qualified, first accepted basis. So I'll leave that to your corporate decisions, what you guys want to do. Personally, I would stick with I don't want to take the first person who's qualified who walks in that door, but each scenario is different. If you've sat on your unit for several months, maybe that works for you. I'll leave you guys to figure out how you want to implement that new policy, but it does have to be done. Mandatory credit reports. These are now landlords are now required to provide the applicants with a copy of any consumer credit report that they obtained within 7 days of receiving the report. It's no longer the case where you provide a copy of the report if you denied them based on something found in the report. You have to do it within 7 days in all situations if you use a report. And it can be sent by either personal delivery, mail, or even email. And there's some other changes involving email we'll talk about later that are interesting, but for right now, we'll just move on. So that's AB 2493. AB 2801 talks about security deposit accounting changes. Again, a lot of changes going on with the security deposit law now. There was this, I'll say, story that was passed around the legislators that landlords were using the tenants' security deposits to upgrade their units. And of course, the legislators said, hey, the landlords shouldn't be upgrading their units. They should be limited to charges that are reasonable. And so they went and changed the entire security deposit law. So now the AB 2801 changes the law to limit permissible claims against tenants or their security deposits to only those cleaning services and repairs that are reasonably necessary to restore the unit to the same condition it was in when it was given to the tenant, exclusive of ordinary wear and tear. Now, I can hear you guys thinking this already. That's what we do anyway. And I agree with you, but there are some new limitations that you'll need to understand and implement in order to be in compliance with this law. So reasonably necessary limitations apply to materials and or supplies. Now, what does that mean? There is no definition of reasonably necessary. So if you buy a bottle of, let's say, Clorox or Lysol, and you use half the bottle cleaning, do you only charge the tenant's security deposit for half of that bottle? I don't really know because there's no definition of reasonably necessary. So it'll be interesting to see how this plays out over the upcoming years. But it also includes labor provided by the landlord, their employee, their contractor rather, and they specifically mentioned professional carpet cleaning. So how are you going to document the condition that the carpet was in prior to the inception of the tenancy? So you're going to have to do that. And part of that answer is the next bullet point there, new photo requirements. So landlord is now going to be required to take 3 separate sets of pictures to be in compliance. And there's 2 different trigger dates here. As far as I'm concerned, you might as well just start. Most of you have already been taking some of these pictures anyway, and we've been talking about this for years, but you might as well just start complying with these right away. Forget the trigger dates, do it today. The first is April 1st, 2025. You're going to be required to take photos of the unit within a reasonable amount of time after the tenant vacates, but prior to any repairs or cleaning being done. So the tenant vacates today, or you get a lockout today. Tomorrow you go in and you take your pictures before you've done any sort of cleaning or work. And then you're going to have to take pictures after the cleaning and repairs have been completed as well. And as of July 1st, 2025, you're also going to have to take pictures of the premises immediately prior to or at the inception of the tenancy. Now, we've been talking about that for years. Most of you are already doing that. That's what defends you when the tenant comes back and says, oh, I gave this property back to you in a condition that was better than what you gave it to me in. So, I don't have the time to go into instruction, and I think there's an upcoming seminar on how to take these pictures, what to do. Let me put it to you this way. I wouldn't use my camera to do them. I would they're cheap. You can get them at Sam's Club, Costco, maybe $20. Get a good little disposable handheld, they're not disposable, I'm sorry, a little handheld camera that can put the date and time stamp on there. Use that, and it'll have a zoom on it, and you can take fantastic pictures. The more you take, the better. And you're going to end up keeping them digitally, of course. If you want to go the extra mile, what you could do would be print them out and have the tenant sign off on the back of them as you do the pre-move-in inspection. So that's up to you, but you are going to be required to take those 3 sets. at the inception or prior to the inception of the tenancy, when the tenant vacates, and then after you've completed any repairs or cleaning. And then let's talk about the itemized deductions. They're still required, except now you have to include the photos and a written explanation for any cost of repairs or damages that you're charging them. So how are you going to explain, I had to clean the carpet because I had to use a professional carpet cleaner to clean the carpet because it was not in a condition that I gave it to them in. Okay, will that be enough? Probably not. Why wasn't it in the same condition? Well, because I moved the couch and they had melted a candle and it dripped on the carpet, or they had a dog in there or a cat in there that urinated all over the place. And you've taken the pictures of that and you're documenting it, but now you have to write it out in your security deposit accounting. And it does say that parties can agree after the termination of the tenancy that the accounting may be sent by email. The pictures can certainly be sent by email. You can also provide the tenant with a link to that. So, maybe that makes sense. If you're using modern technology, for example, we use OneDrive. You can share that file with the tenant. And when you share that file with the tenant, you can actually put a expiration date on there. So in other words, maybe you share it for, 2 weeks and then it's no longer shared. So there's a lot you can do with it. It does make it easy to do it by email. You know, you choose whether you want to mail it or do it by email. That's up to you guys. All right, let's move on to AB 2747 and SB 924. I combined these because they work in the same manner and affect the same laws. So this is now a mandatory offer of positive credit reporting. Now, before I get into the details on this one, I want to say, when this first popped up a couple years ago, I think it was 2023, this law popped up, maybe 2022. It was limited to those tenants who were low-income tenants receiving benefits. And at the time, I know I went against the whole industry and I said, this actually can be used in a very beneficial way for landlords. We should all start just doing this because let me be clear how this could be a benefit to the whole industry. Now that it's mandatory, we're going to start doing it. We're going to be offering them positive credit reporting. You might consider just doing the positive credit reporting whether they ask for it or not. Many of you use a management software that automatically allows you to do it. And if you don't, you're going to be required to look into figuring it out, how to do it anyway. But the reason I like mandatory positive credit reporting is because when you go to consider a new tenant an applicant, and you're looking at their credit score and you see 9 months of positive credit reporting, and then all of a sudden it drops off a cliff and there is no positive credit reporting anymore. What do you think is going on? They're probably being evicted. They've stopped paying their rent. They're now in an eviction. And so I can't guarantee that, of course. It might be something you want to ask about, but it's a great indication that they may be in the middle of an eviction. And the reason I say that's a benefit is, as you know, California seals all the eviction records. So it's very easy for tenants to lie. Have you ever been named in an eviction? No, I've never been named. 99% of the time, the landlords aren't going to be able to really conclusively prove that the tenant is lying. Well, if you've got 9 months of positive credit reporting, and then all of a sudden there's no credit reporting, or better yet, bad credit reporting, then hey, this tenant's not paying their rent, or something's going on that I need to dig into. Now, I will say that the law, to the best of my reading, I couldn't find anything in there that prohibits landlords from negative credit reporting. So if you're going to go the mile of positive credit reporting and then they stop paying their rent, you may think about, and you may need to hire an attorney to dig deeper into this to figure out, can you negatively report their non-payment of rent? But it's at least one consideration we'll start figuring out over the next year. But anyway, let's jump back into this. So this requires landlords of all residential properties to extend to all tenants an offer to report positive rental payments to at least one nationwide consumer credit reporting agency. And there are some trigger dates, of course. Leases in existence as of January 1st, 2025, you will have to begin doing this on or before April 1st, 2025. And annually. In other words, you're going to have to make the offer April 1st or before, and then every year you're going to have to reiterate that offer. Leases entered into on or after April 1st, 2025, it's upon the execution of the lease. So really, April 1st, 2025 is the drop dead date. Everybody's going to have to be complying at that point. The offer can be made provided by mail or through email. If you do choose to do it by mail, you are required to provide the tenant with a self-addressed stamped envelope so they can mail the form back. And as Jeff mentioned, there is a form for this that he's worked on. So look to AOA to grab a copy of that form. It's brand new. You are allowed to recover your costs, at least a portion of them. You're allowed to charge either the lesser of either the actual cost or $10 a month. If the tenant opts out or fails to pay the fee, there is a 6-month waiting period to opt back in. So let's say they don't pay the fee next month and you stop reporting, they have to wait 6 months before you have to start positively reporting again. The remedies for a tenant's failure to pay the reporting fees is that the landlord is permitted to terminate reporting if the fee remains unpaid for 30 days. What you are not allowed to do is you're not allowed to use their rent to pay it. You're not allowed to use their security deposit for it. And you're not allowed to file an eviction based on the failure to pay that fee. So you are limited to just simply not reporting if they don't pay the fee for 30 days. You'll have to decide if you even want to charge that fee. That's up to you. Exemptions. There is one exemption, and the way it's worded in the law is a little odd. It's hard to understand initially, so I'll try to explain it to the best of my ability. Landlords who own a property with 14 units or less are exempt unless both of the following apply. The landlord owns more than one residential rental building, and the landlord is a REIT, a corporation, or an LLC with a corporate member. So many of you are saying, where have I heard that language before? It's in the Tenant Protection Act. It's exactly what, that's an exemption in the Tenant Protection Act for single-family residences that are not owned by a REIT, a corporation, or an LLC with a corporate member. And the thought process behind it is, hey, we're trying to get corporate America out of being a landlord in California. So that's why they make these exemptions. So again, if you own 14 units or less, you're exempt unless both apply. So I had somebody saying to me, but Mike, what if I own multiple properties? Well, that's fine. You can own multiple properties and you're still exempt as long as they total less than 14 units, as long as those properties aren't owned in a REIT, corporation, or an LLC with a corporate member. All right, so the approach when the tenant, what do you do when a tenant is utilizing these remedies of theirs? What do you do when they tell you, I'm doing repair and deduct. You didn't fix the hot water heater. I went out and fixed it, so I'm not going to pay my entire amount of rent this month, and I don't want a negative credit report. Or they say, I'm not paying you because of habitability conditions in the unit. So first they have to notify you in writing prior to the date that the rent was due. So if rent's due on the 1st, and let's say the 1st falls on some day other than a weekend or a holiday, let's say it's a Tuesday. Rent comes due on Tuesday, they don't pay. On Wednesday, they send you an email saying, hey, I'm not paying because there's habitability issues over there. Do you have to report a positive credit report that month? No, because he notified you or she notified you after the date rent became due. Otherwise, you have no requirement to report positive payments. So again, if they aren't paying their rent on time, you have no obligation unless they meet that criteria. They put it in writing prior to the date the rent was due. All right, moving on. Believe me when I tell you, there's a lot more to these laws. I've tried to boil these down to English and keep them on one slide. So I apologize in advance if some of the text is small for you guys to read it. Hopefully it's big enough. But like I said, AOA has the slides. They can send them to you afterwards. All right, SB 1051, domestic violence, changing the locks. Now, it seems like every single year we deal with domestic violence on one level or another, and it oftentimes deals with locks and family members and who's protected and who's not. But this applies to leases executed on or after January 1st, 2011. So we're talking almost 14 years ago. Requires landlords to change the locks to the victim tenant's rental units under these following situations. First, it's got to be an eligible tenant, and we'll talk about that below. It's got to be a written request, and they have to provide you with the required documentation. So an eligible defendant is defined, defendant, I said, that's funny. An eligible tenant is defined as either a tenant, an immediate family member, or a household member who's a victim of abuse or violence, okay? So that we'll call them the victims. They have to give you a written request that's accompanied by either a temporary restraining order, an emergency, or a permanent protective order. In other words, an order issued by a court. or a written police report. They can use third-party documentation that establishes physical or mental injuries from abuse or violence, or they can use documentation, any documentation that reasonably verifies the abuse or the violence. What does that last one mean? I have no idea. We'll have to wait and see how creative the tenants get when they're providing you with some documentation that reasonably verifies the abuse or the violence. My recommendation to you, though, is err on the side of caution. If you're even, unless it's just blatantly nonsense, if you're at all wondering, should I change these locks? Just go ahead and do it. Failure to change the locks within the 24 hours is going to allow the tenants to do it anyway. By the way, in case I didn't mention it before, when the landlord changes the locks, they have to do it on their dime. They have to pay for it and they can't pass that through. But if you don't do it within the 24 hours, the tenant gets to do it with either a similar or a better quality lock, as long as they notify you that they've changed the locks and they provide you a key within the 24 hours. And then you've got to reimburse that tenant within 21 days of them changing that lock. So you might as well do it. Many of you I know, when you turn a unit, you keep the old locks and the keys for use on a different unit. So, you know, it doesn't, like I said, if you've got any question whatsoever, err on the side of caution, just go ahead and do it. And I would encourage you to document, not only document it in an email or a written letter. Hey, you gave me the written report, you complied with the law, I changed your locks as of this date, I've given you a copy of the key. But also you might want to document it on the lease or through some sort of an addendum that the locks have been changed or something along those lines. Okay, AB 2347, eviction delays. Now, this is the big one that everybody's been hearing about all year long. As most of you already know, when you file an eviction against a tenant and then you serve that tenant, provided you serve them personally, they have only 5 days to file a response with the court. And I know LA has its own bizarre reasons for not mandating it to being 5 days. Technically, legally, it is 5 days. But what this law does is it changes it. It changes it to 10 business days. It excludes Saturdays, Sundays, and other judicial holidays. And what that really results in is once the tenants are personally served, they essentially have 2 weeks or even more, depending on how the days play out. They have about 2 weeks to file a response to the unlawful detainer. On top of that, it streamlines this is one positive of the law. It does streamline the motion process, or at least the responsive pleading process. In other words, after you've filed your summons and complaint, oftentimes the tenants will file a demur or a motion to strike. This changes the requirements for that. It requires those hearings to be held. Oftentimes what the tenants will do is they'll set it out for 30 days. All they're doing is delaying it. 99.9% of demurs get overruled and motions to strike. It's just a delay tactic. This new law requires those hearings to be held within 5 to 7 days. It also allows oral oppositions, although in most cases I don't recommend that. I still recommend you do a written opposition. But there are situations where they're just so blatantly ridiculous that an oral opposition would be fine. But it does cut down, like I said, it cuts the time down from 30 days down to 5 to 7 days. So that's a positive out of that law. All right, SB 611, prohibition on fees. Jeff mentioned this. This new law prohibits landlords from charging tenants fees for serving any kind of termination notice or paying the rent or security deposit by check. I will remind you there are laws on how you are required to allow tenants to pay the rent. If they do decide to pay it by check, you're no longer allowed to charge them any fee for that. It's got, believe it or not, this is kind of alarming to me. This protection under this law is now extended for qualified commercial tenants. So let me stop here for a second before we go on with the details of this law. What you will see in this law and another law is that the state of California is now starting to reach in from residential. They've always tried to regulate all of it, every aspect of it, but they've pretty much left commercial tenancies alone. Now you are starting to see the state reach in to the commercial relationships, and they're starting to implement some of the same laws that we see in residential, which concerns me a lot. There's a lot of reasons for that. At least on my part, I have very strong opinions about why they're doing that. I'll sum them all up by saying they're trying to take away your private property rights on multiple levels. But the bottom line is this law in particular impacts commercial tenancies as well. So for a qualified commercial tenant, it's defined as either a micro enterprise, which is 5 or fewer employees, including the owner, and business does not have access to loans or financial funding. Well, I don't know any businesses that don't have access to any financial loans or funding. I guess they could exist. Or a restaurant with fewer than 10 employees, or a nonprofit with fewer than 20 employees. So if you're like many landlords out there, you have some commercial property as well, understand now that these rules are in place and you may need to modify either your application or to ask these questions. Are you a restaurant with 10 or fewer employees? Are you a nonprofit with fewer than 20 employees? How many employees do you have? You may need to modify your documents moving forward on that. Okay, and the requirements are the tenant must provide written notice stating they're a qualified commercial tenant, telling you what the number of employees are, and the notice has to be provided within the previous 12 months. It has to be made at the execution of the lease and annually every year. If they don't do it, that law doesn't apply to them. So if you have a provision in your lease, for example, that says, we're going to charge you $50 for every notice we have to serve you, and the tenant doesn't come up and comply with these requirements, you are permitted to charge them that $50. If they do meet the requirements, they have to meet it every single year for that to remain in effect. And like I said, remember, there are laws, if you want to look them up. Civil Code Section 1947.3 lays out specifically what forms of payments landlords are allowed to accept. So it might be beneficial to take a look at that. All right, SB 1103, commercial tenancies, rent increases, leases, and chems. And again, here we are, reaching into the commercial world with traditionally residential limitations. So notice periods for rent increases model residential requirements now on your commercial tenancies. So for example, if you increase the rent 10% or less, you're required to give a 30-day notice with information on the provisions of this law. What does that mean? You've got to provide them information about this new law that says, hey, these are the limitations. If your increase on a commercial property is greater than 10%, it requires a 90-day notice with that information on the provisions. So that's going to change your commercial notices right off the bat, especially your changes in terms of tenancy. It also requires that you give mandatory copies of translated leases. And so this is another thing we see out of the residential world. If a lease is negotiated primarily in another language, there's the 5 big languages. You can check out the Department of Real Estate's website for a lot of these forms. But it's specifically, if it's negotiated primarily in another language, the landlord's got to provide a copy of that translated lease. Now here, in a commercial setting, the landlord has to do that for a qualifying commercial tenant, and they have to do it upon the execution of the lease. And this is interesting. Unlike residential tenancies, where if the tenant brings somebody along who translates English, let's use Spanish, for example, because that's very prevalent. If they speak Spanish and they bring someone along who's translating between them in Spanish and the landlord or the landlord's agent in English, you don't have to provide that copy. That exemption does not exist for commercial tenancies. So even if they bring an interpreter in a commercial setting, you still have to provide them a copy of that translated lease at the inception. On top of that, you've got to post notices. It's got to be posted in the notice in which the lease is signed. So in case you have multiple offices, it's got to be posted where the notice is signed. It's got to be in the language that the agreement was negotiated in. And it's got to state this specific language. I don't need to read it to you. It's right there. What happens if you don't comply with this law moving forward? The tenant can rescind that lease. So if you've just signed a 5-year commercial lease on something and all of a sudden you didn't comply with this, don't be too surprised if the tenant's not making it and they turn around and rescind that lease. When can they rescind the lease? It doesn't say. So theoretically, they can be doing great for 2.5 years and all of a sudden they can't pay their rent, business took a downturn, and they talk to an attorney who says, by the way, did you get a translated lease at the inception of the tenancy? No, I didn't get that. Oh, well, then we'll just rescind the lease. Just move out. So be careful with that. And then finally, Civil Code 1950.9 prohibits fees to recover building operating costs. So we're talking about CAM charges here. Those costs have to be allocated proportionately amongst all tenants, and the tenants have to be provided supporting documentation. And again, failure to comply equals an affirmative defense. So, excuse me, if let's say you serve a cure covenant notice because they didn't pay their CAM charges, and the tenant says, hey, the landlord never complied because they never provided me with supporting documentation, you just lost that eviction case. So again, my concern here is not so much the rules that are being changed. My concern is the fact that California sees it necessary now to start expanding these type of residential limitations into the commercial setting. All right, let's talk about some fair housing laws. Let's just jump right into SB 1137. So this one, it basically expands the basis for discrimination claims by talking about combinations of characteristics. So most of you already know California has a whole slew of characteristics, sex, sexual orientation, gender, whether you're pregnant, your race, your national origin. I think there's about 15 categories now. And what this law does is it clarifies that a claim of discrimination can be brought based on a combination of characteristics rather than just a single characteristic. Oh, you discriminated against me based on race. Well, it was a little bit of race, and it was the fact that I was pregnant, and it was a little bit of my national origin. So you can combine all of these categories now, and that's really what this law is about. Um, when a claim for discrimination is filed based on multiple protected classes, it cannot be separated into distinct categories. And it's got to be investigated to determine whether the discrimination or the harassment occurred based on a combination of these characteristics. That may sound like, so what? I promise you, it's more dangerous than it sounds. It widens the umbrella of liability for landlords, or it widens the requirement that you defend these cases more vigorously. It widens their claims of action against you. So it's more insidious than it sounds off the top. There are additional fair housing laws to talk about those, so we'll move on. AB 1815 is now, you can be charged with discriminating based on hairstyles. So this expands the Unruh Civil Rights Act and provides a declaratory statement that the protected class of race includes additional traits associated with any specific race. And it includes, but is not limited to, hair texture, protective hairstyles, braids, locks, and twists. And that's right out of the code. So now you can be, let's say you had a female with a short haircut apply and you didn't accept them, or you had a male that likes to wear their hair up in a bun on top of their head that applied that didn't accept them, and you didn't accept them. They could now turn around and say, by the way, you discriminated against me based on my hairstyle. You didn't like my hairstyle. So as I say in the tenant screening seminar all the time, make sure your screening criteria is based on objective, non-discriminatory criteria. It's as if you had blinders on. It's almost as if you don't even want to see what they look like. Let's do it all over line. I'm just going to base it on your credit score, your tenant history. Oh, wait, your tenant history is coming up. Are you going to be able to discriminate or reject someone based on tenant history? We'll talk about that a little bit later. So let's move on. Let's talk about some affordable housing laws. And we'll talk about AB 846. For those of you on the call that have affordable housing, there are some rent increase limitations. Now, this is a major change, and affordable housing is a complex topic. So please take this new law to your attorney that deals with affordable housing and have them walk you through it. But basically, the California Tax Credit Allocation Committee is now required to implement regulations regarding maximum rent increases for properties that use tax credits. So what they're doing now is they are going to implement maximum increases on these properties that receive maybe Section 8 tax credits, something along those lines, federal tax credits for keeping units low income, very low income, things of that nature. The regulations limiting the annual rent increases have to be in place by June 30th, 2025 for specific tax credit properties who received their allocation of tax credits prior to April 3rd, 2024. So you already know by June 30th, 2025, those regulations have to be in place for any of you that got your tax credits prior to April 3rd, 2024. So if that's you on this call or on this webinar, like I said, set an appointment with your attorney that handles affordable housing to figure out exactly how this law is going to impact you. Basically, what is transpiring, there was a letter that Attorney General Bonta put out some time ago. I don't know the exact date, but he clarified that Section 8 is in fact governed by the Tenant Protection Act and is subject to the rent increases thereunder. And I know a lot of tax credit properties, when you come to the end of your tax credits, if it's not renewed, you get to take those tax credit properties and units out of that protection program, out of low housing, and you get to take those rents to market rent. And what I would tell you is that's a very complex area. Again, set a meeting with your attorney before you do anything along those lines. All right, let's see. AB 653, reporting requirements for housing authorities. July 1st, 2025, and annually thereafter, all public housing authorities must publish the data regarding their monthly success rate. How many people are they placing? Payment standards being used. What are they paying? Inspection wait times for lease ups. That's the one that will be most interesting for you guys who participate in the Section 8 programs or VASH, anything along those lines. And their search times for new voucher holders to obtain housing. In other words, how long were you on that waiting list? And that'll be really good information for the public to know. It's got to be made public, not just housing providers, as of January 1st next year. And the purpose is to create opportunities for recommendations across authorities to improve their efficiency. So I think it's a great thing. I don't want to knock them for trying to improve their efficiencies. But again, I'll caution everybody on this webinar. The reason they're going down, a lot of people are really hesitant to take federal subsidies, whether it's Section 8, VASH program, anything along those lines, for a couple of reasons. One, the inspections can be horrendous. Two, evicting these tenants are oftentimes plagued with emotional problems, mental problems. They cause problems at the properties, and historically, there's a high level of eviction with them. So like I said, a lot of landlords are hesitant to accept these. And what I anticipate you seeing over the next decade is being forced more and more through regulatory means, being forced to accept these. And so what they want to do is change that opinion of these programs. They want landlords to start accepting Section 8, for example. California has also they have not made it a secret that they support the universal basic income, which is where the government is paying a portion of your income every month, and that will be considered a subsidy, and landlords will be required to take it. They'll be required to consider it. So we're moving into an era where the government is funding more and more of the tenant's rent. And so as a result of that, like I said, Section 8 at least, and these housing authorities are going out trying to clean up their image and trying to do better. So like I said, I think it's a good thing. All right, AB 2430, the removal of city monitoring fees. So for those of you who have affordable housing and the city is charging monitoring fees to make sure you're doing everything you're supposed to, this prohibits the cities and counties from charging those fees. And it applies exclusively to projects that have 100% of the units reserved for low-income households or up to 20% of the units for moderate households. Several conditions that the project will need to comply with in order to qualify for this protection, meaning you guys will need to qualify, your project, your building will need to qualify for this protection. I don't have the time to go into all of those today, but you can look up the law and like I said, set an appointment with your affordable housing attorney. And current projects with monitoring fees that qualify will have to have them removed. So that's a positive thing. All right, let's talk about some laws that impact buildings and health and safety. AB 2533, streamlined ADU permits. This is great. Expands the current program, which allows specific unpermitted accessory dwelling units. So if you have an unpermitted ADU on your property, there is a streamlined process for you to get it permitted. And now this is going to also apply to junior ADUs as well. And it requires the local agencies to provide public information about the process of going through it. What are the checklists that they're going to have you check off to get your permits, and advisory information about the right to have a confidential inspection by a third-party contractor to determine the condition of the unit before you even submit your application. So again, for anybody who's got an unpermitted ADU or a junior ADU, I think this is fantastic for you. This is a way to get that permitted. Now, there's a downside to the ADUs. The downside is I know a lot of clients of mine have considered ADUs. Before you decide to pull the trigger on it, I would suggest that you ask, what is the impact? Do I already have a couple units on the property? Will it subject me to rent control either now or at some point in the future? So, if you're even contemplating ADUs or you have unpermitted ADUs, consider the impact and look into this law to getting it permitted. Okay, let's see. Oh, and it does limit the fees and penalties to facilitate bringing these unpermitted units into compliance. All right, AB 2684, housing elements and extreme heat. So last year I talked about this. There are mandates coming up because of the concerns about the environmental impact we're going through and the I forget what they call it, but it's this extreme weather cycle we're going through. Last year I talked about these mandates. For example, many of you are going to be shocked in a few years when you find out that the city or the state is requiring you to get rid of your hot water heaters and you're going to be installing heat pumps. And so it's extremely expensive, but those are some of the mandates that are coming down the line. And this housing element in particular is now, it amends the government code and is now adding extreme heat hazards for review in connection with housing elements or local hazard plans. So we're going to talk about this a little bit later, so I won't get into too much detail right now, but many of you know City of LA contemplating, mandatory air conditioning right now. You're going to see this come up more and more where, hey, we have these extreme heats, the environment is changing, and maybe it is, maybe it's not. But as a result, they're going to be building, cities and counties are going to be building this extreme heat hazard into their housing element and their local hazard plans. Next revision is set for January 1st, 2028, and it's going to require review and updates addressing hazards of extreme heat. So by then they're going to start, 3 years away from that. Okay, what do we do about this extreme heat? Don't be surprised. LA is leading the charge, but don't be surprised when you start seeing more and more cities saying, yes, air conditioning is mandatory and it's got to maintain a maximum heat in the unit of, for example, 82 degrees. Extreme heat means increasing temperatures resulting in a heat wave, heat health event, heat watch, or a warning, or a proclamation of a state of emergency. That's important, very important. We're going to come back to that later. Proclamation of a state of emergency. So if we have a very hot day, and that hasn't been defined yet, but if we have a very hot day, a city or county or the state can declare a proclamation of a state of emergency. Why do you care about that? Because of rent increases, Penal Code 396. We'll talk about that at the end of the webinar. This is the precursor to future mandates to install air conditioning or HVAC systems, like I just said. So be aware of this. All right, SB 1465, substandard buildings. This is big. This is a whole inspection scheme that's been put on steroids. As the slide says, it mandates new inspection requirements by local entities, and I mean mandates. It expands and clarifies the definition of substandard buildings. The key word there is expands. It expands the definition of residential rental units. Provides relocation assistance to tenants who have to vacate as a result of an order to vacate by a local enforcement agency. Let me bump back up to that, expands the definition of residential units. Residential units are any unit that's got somebody occupying it. It doesn't matter what it's zoned. It doesn't matter what its permits say. And the reason they're doing this is they're expanding the ability to declare a building substandard, just so you're clear about what the goal is here. And like I said, it provides relocation assistance to tenants who have to vacate as a result of either a city or a law enforcement agency saying, hey, this is illegal construction, you've got to vacate. It requires those enforcement agencies to institute actions or proceedings for uncured violations or nuisance conditions. So I'll tell you right now, if an inspector came over to a commercial property you happen to have, or even I've seen things as crazy as there's a tool shed on your property and it's been tenants sometimes who have rented that tool shed out to a human being to live in. If that's the case, I guarantee you're going to have a violation or what is called a nuisance condition, and it will require the city to institute an action or a proceeding against you if you don't fix it right away. If the building is deemed substandard solely on being illegally occupied, they wouldn't institute an action against you immediately, but it's going to require that you sign a declaration that says, hey, I didn't put them in there. I didn't authorize them. I have no idea that they're in there. And you're going to have to immediately implement eviction proceedings against that person. Now, the problem with the eviction proceedings, depending on the location of your building, is that would fall under it would fall under an order by the court or an order by a government agency. In most jurisdictions in Southern California, that's going to require you paying the tenant relocation fees, and that can be a lot of money. In LA, roughly $25,000, depending on a few factors. So be diligent about your buildings, your sheds, be inspecting your properties, garages. I have a case I'm working on right now. Tenant moved somebody that the landlord has no clue who they are. Tenant moved somebody into the garage so that the tenant can charge them rent. Well, guess what? The landlord's now on the hook to deal with it. So this can get you in a lot of trouble. The court can retain jurisdiction up to 18 months after a receiver is discharged. So what am I talking about there? This law actually authorizes, and this is where it gets a little scary. It authorizes the court or the city or a county or even a tenant's organization to request a receiver be assigned to your property if you have these conditions going on. And you don't want a receiver assigned to your property. But if you do happen to get one and then you get out of that receivership, the court's going to retain jurisdiction for up to 18 months after that receiver's discharge. And I promise you, that will cost you a tremendous amount of money to get out of that. So anyway, subsequent purchasers are subject to the order to abate in the costs of any receiver appointed. So if you are considering purchasing a property, not only do you want to do a thorough inspection, but you also want to ask the question, is there anything that I should know about in connection with any sort of substandard conditions, any sort of nuisance on the property that you've received any complaints about over the last year or two, maybe even 3, something to consider when you're doing your due diligence. All right, now let's talk about some miscellaneous laws. Let's start with the Tenant Protection Act. SB 479 clarified it. It amends it and clarifies the definition of a natural person for owner occupancy. This is actually a good thing for you guys. It defines natural person to include a beneficial owner with at least 25% ownership interest. So what was happening is tenants' rights advocates, if you owned the property in a trust and you wanted to terminate that tenancy for owner occupancy, assuming that provision is in your lease, like it is in the AOA lease, you could do so. But if it was in a trust, the tenants' rights organizations would argue you're not a natural person, or the trust is not a natural person. So this has clarified that to define it as somebody with a beneficial owner with at least 25% interest. All right, AB 2622 contractor requirements. This increased the threshold amount. The old law said that anything above $500 or greater in repairs had to be done by a licensed contractor. This new law says it's $1,000 or greater. So good for you guys. That helps. AB 2454, mandatory water well testing. You know, this is really just, it was a changed law, so I threw it in, but this is going to impact those of you who might be on the call who, rent a property, a horse property out in Atalanta or Palmdale or Lancaster or points beyond that, somewhere where you're using local well water. But basically what it says is if you have that property and you're renting it out and it's got a local well on it, not only do you have to have it tested, but you've got to provide the resident with a copy of the test results within 10 days of receiving it. And it prohibits you passing those costs through to the tenant. All right, AB 2898, exemptions to unbundled parking. So back in 2024, they passed a law that said, hey, starting in, January 1st, 2025, certain properties in these counties, Alameda, Fresno, Los Angeles, Riverside, Sacramento, San Bernardino, San Joaquin, Santa Clara, Shasta, and Ventura, who got their certificate occupancy after January 1st, 2025, had to unbundle the parking charges from the lease, and they had to put the parking in a separate contract. Why did they do that? They didn't want landlords including any fees for parking in increases in rent. And that's going to continue moving forward. This amendment exempts landlords who receive either Section 8 or VASH. You are allowed, VASH is the veterans, it's the equivalent of Section 8, but for veterans. Those landlords who operate in those programs are allowed to continue with that unbundled parking on newer properties. All right, so let's talk about some expanding and emerging trends. And we'll talk about the continued expansion of landlord obligation tenants' rights. So this, I'm going to have to shift gears a little bit on you, and I'm going to have to come to another document because there was so much that took place in 2024. It's almost mind-numbing. Now, I did put bullets up here. I'll go through the bullets, but I'm going to go through in greater detail after I'm done the bullets. So Burbank increased the relocation fees and mandated a seismic retrofit. City of Los Angeles has a multitude of new ordinances, too many to list here. I'm going to go through them in detail in a second. County of Los Angeles reduced your rent increase fees, the maximum increase you're allowed, and created an inspection program. Huntington Park passed rent control and created a rent registry. Oxnard increased trash hauling rates by 54% and mandated that owner-occupied landlords who kick tenants out have to live in their property for 2 years. Pasadena increased the trash hauling fee rate between 21 and 63%. Santa Monica and LA competed for who can hate landlords more. And you'll see that as I go through their ordinances in a second. But they have multiple new restrictions and tenant protections. South Pasadena passed a prohibition on substantial remodel evictions. Now you just have to temporarily put your tenants somewhere else if you have a remodel you need to do. Ventura is funding a right to counsel, and we're going to talk about that in a bit. And they have a meeting coming up. I forget the date, but it's coming up where they are going to say, hey, all of you housing rights councils, we're going to give you even more money for this right to counsel fund. And West Hollywood imposed a minimum 1-year lease term. So now that I've said that, bear with me for 1 second because I'm going to pull these up and I'm going to go through them in greater detail so that, you know, for those of you who have properties in these areas, I'm going to go through them in detail. So Burbank, like I said, they increased the relocation fees and created a seismic retrofit. They passed a relocation fee increase equal to 3 times the monthly rent for all no-fault evictions. That began on August 30th, and then they put in that mandatory seismic retrofit. City of Los Angeles, let's go through these. They approved an ordinance to increase sewer rates by 22% for multifamily properties and 27% for single-family properties, with 6 additional increases planned over the next 3 years. They passed a moratorium on all substantial remodels for non-RSO units until June 1st. And the reason they picked June 1st, 2025 is they are working on prohibiting them altogether for non-RSO units. They created a new enforcement program that's applicable to all rental housing providers with properties that are not subject to RSO. All of those property owners are now going to be required to pay $31.05 per unit to pay for the program. It's going to require rental properties to comply with several recently passed ordinances targeting non-RSO owners. That went into effect December 24. Some of those ordinances include requiring property owners to pay mandatory relocation fees to renters up to $12,200 if the owner raises the annual rent by more than 10% or the consumer price index, whichever is lower. It restricts evictions to specific just cause reasons only and includes mandatory relocations fees for all no faults. Those go up to as high as $27,500. Now, these are non-RSO properties I'm talking about. It set a minimum threshold of 1 month's fair market rent before you can file a non-payment of rent eviction. That's been in place for over a year now. It restricts owners from asking certain questions or taking certain actions towards renters, including actions that a tenant claims disturbs their comfort, their repose, their peace or quiet, or interferes with their quiet enjoyment. So this is one that pops up again in their anti-tenant harassment ordinance, which has become incredibly strict now. You need to be really careful how you're interacting with your clients in the city of LA. And they are mandating the continued allowance of pets that the tenants picked up during COVID-19 without the landlord's authority. The city council also voted unanimously to make revisions, like I just mentioned, to the tenant anti-harassment ordinance. And the consequences for violating that are triple the damages. So in other words, let's say a tenant moves out and says, the landlord harassed me, and I spent $3,500 for moving. You're going to be at least triple that if you are found to have violated the anti-harassment ordinance. And like I said, they are revising that thing, so it's almost as if you can't talk to your tenants anymore. That was the city of LA. The county of Los Angeles, like I said, they reduced their rent caps and created an inspection program. They passed a pair of ordinances, basically that caps out their maximum rent increases to 60% of the consumer price index with a maximum of 3%. So if the consumer price index was 10%, you'd still be limited to 3%. If it's anything less than 10%, you're going to be limited to 60% of whatever that consumer price index is. Let's see. Smaller owners with 10 or a few units will be allowed an additional 1% increase each year over and above that 60% CPI limitation or a maximum of 4%. And luxury owners will also receive an exemption to that. Huntington Park created a new rent control and registry. I mentioned that. Oxnard, they increased their trash rate to 54%. And like I said, they mandated the owners live in their properties for 2 years. Pasadena increased their trash rate as well, as I mentioned, somewhere between 21% and 63%. They approved an ordinance that passed it, and that started on July 1st, 2024, but they intend to implement additional increases all the way through 2028. They're really going to stick it to the landlords in Pasadena. Measure H, still one of the most confusing, difficult to comply with ordinances out there, and they keep changing it and amending it. Just not a good situation in Pasadena right now. Santa Monica has a slew of new restrictions. Let's go through them. Now, their changes impacted almost every single one of their tenant protection ordinances. So we'll go through them one by one. Housing as a status as a protected class. I mentioned this earlier in the webinar when I said, what are you going to do about applicants who apply and you traditionally have said, okay, you need a good and verifiable tenant history. That, if you've got a property in Santa Monica, that may have to change because housing is now a protected classification. And what that includes is non-discrimination based on housing status right now, which could mean they're homeless. And it also includes a lack of rental history. So if you've got a tenant that's got a lack of rental history or they're homeless right now, you cannot use that as a basis for terminating or for denying their application. They've also amended their tenant protections to add a permanent relocation fee for properties where the landlord gives a rent increase, whichever the lesser is of CPI plus 5% or 10%. So we're talking properties that have to comply with the Tenant Protection Act. If a landlord gives an increase that's greater than that, for example, if the property doesn't fall under the Tenant Protection Act, like a single family home, and the tenant notifies the landlord, hey, I don't want to pay that within 120 days of the increase, the tenant can move out, but the landlord has to pay that tenant relocation fees for what they call economic displacement. They increased the reasons for permanent relocation fees, including where the tenant elects to vacate after a temporary relocation. So you're trying to upgrade their unit, they temporarily relocated, and now they say, we're not coming back. You've got to pay them relocation fees. If the code enforcement has determined the tenant's been forced out due to any sort of misconduct on the landlord's part, such as harassment, threats, derogatory language, then you're paying relocation fee. If the building officer determines that there's a health and safety condition in the units that can't be fixed, you're paying them relocation fees. If the tenant elects to give you back the property in a bootleg unit, you're paying them relocation fees. If the tenant vacates the unit claiming it was due to harassment, illegal lockout, uninhabitable conditions, or any sort of constructive eviction situation, you're paying them a relocation fees. The city also expanded their buyout and cash for keys code, which covers non-rent controlled units. Now, landlords are required to pay the minimum. It covers all, I apologize, I was talking about a different code. It is expanded, the buyout, and now it covers all units, whether that unit is subject to rent control or not. And we'll talk about that minimum buyout requirement right now. Santa Monica changed their law to say that all buyout agreements or cash for keys are required to be for no less than the permanent relocation fee amount. So you can't even negotiate that. You can negotiate up, but you can't negotiate down. And a failure to file that buyout agreement with the city after it's been signed raises a defense to an eviction. All right, and then finally, they've got some new disclosure language where they're going to require disclosure forms to include statements regarding bad faith, tenant harassment, and tenant's entitlement to the permanent relocation fee amounts. So bad faith, harassment, and you're entitled to these permanent relocation fees are going to be new disclosure requirements. So if you have a property in the city of Santa Monica, I would immediately contact the housing department over there and figure out what are these new disclosures. Does the city have a copy of them? Is the city drafting them? For example, the County of Los Angeles, they draft a lot of the required forms that landlords use. It may be the case that Santa Monica intends to do that as well. All right, Santa Monica also created new defenses to evictions. Like we've been talking about this whole time under the umbrella of Santa Monica, they've created bad faith and excessive rent increases. So Now, if a tenant complains, or if you had an unsuccessful eviction, let's say the tenant failed to pay rent, you're trying to evict the tenant, and there's some technical deficiency in your case that isn't discovered until you're halfway through the case. You figure out that the city never cashed your check, so technically your registration fees aren't paid, and so your eviction now is fatal. It has to be dismissed. If you've got a eviction, an unsuccessful eviction, or the tenant has complained to you anytime within the last 180 days, any sort of increase in rent can be claimed to be in bad faith and harassment. So, like I said, it's got a whole list of things that can be considered bad faith. Let me go through them. Imposing a rent increase within 6 months of an unsuccessful eviction. Imposing a rent increase within 6 months of a renter's complaint regarding any sort of habitability issues. Imposing a rent increase when price gouging protections are in effect. So let's talk about that. Going back, I've mentioned this a couple times. We've got Penal Code 396 we need to deal with, and we will, at some point in the future, have to deal with these heat wave proclamations of a state of emergency. When those go into effect, when any sort of state of emergency goes into effect, you have to be cognizant of price gouging laws. Price gouging laws are going to limit you to 10% or less during any sort of a state of emergency. And so, it's really important that you just pay attention to that stuff. All right, not only, as if all of that wasn't enough, Santa Monica also created a list of prohibited activities. Unlawful activities are now to be explicitly defined as harassment when done in bad faith, including self-help evictions, that's a no-brainer, refusal to accept rent, retaliation, refusing to cooperate with the renter's request to replace an occupant who moved out, or offering to, this one's important, offering to buy a renter out within 6 months after the tenant already told you, hey, I'm not interested. All of that can be deemed as bad faith and is now a prohibited activity, which would expose you to a claim of tenant harassment. That's welcome to Santa Monica. All right. South Pasadena, like I said, they have a prohibition on substantial remodel evictions. That's never going away. Ventura, we talked about, and West Hollywood, we talked about. On top of these, I've mentioned this a couple times now, be cognizant of Penal Code 396. It is a relatively new defense to evictions. It's only been in place, it's only been utilized relatively recently, but it is a complex topic. And what I'm talking about is Penal Code 396 specifically states that if a landlord price gouges, and price gouging is defined, they do actually have a section on leases. They have a bunch of different sections that define what is price gouging in various situations, like a retailer. I'll never forget when I was in Miami and there was a hurricane. Try buying a chainsaw after a hurricane. The prices went up 400 or 500%. That would be defined as price gouging. If there was some sort of an earthquake and all of a sudden gas went up 300-400%, that's price gouging. With landlords, they define it as basically, I'm paraphrasing, raising rent in excess of 10% during a state of emergency. And there are some questions now. Well, what constitutes a state of emergency? What constitutes who has to enact it? Is Section 8 covered by that? What about it's a very complicated topic. So just be cognizant of your rent increases. Anybody who's giving a rent increase greater than 10%, you might want to check and see if there's any sort of state of emergency in effect. All right, and then we also have the Violence Against Women's Act requirements. So again, this law has been on the book for a long time, never been raised as an affirmative defense to evictions until relatively recently, and now I'm starting to see it. It's in a checkbox, or they're checking the boxes. For all of you people out there, and there is a whole list of properties that this may or may not cover. Again, sit down with an attorney that focuses on affordable housing and figure this out. But basically, if you've got a tenant that's got Section 8, you are required to serve those tenants with two documents, really. One is about their rights and another is a declaration. And those have to be served at two different times. They have to be served at the inception of the lease and upon termination of the tenancy for non-payment of rent. If you don't comply with that, it's a complete defense to an eviction. And I know most of you on this webinar right now are sitting there saying, or anybody who's got Section 8 is sitting there saying, I've never even heard of this. And you're right. Nobody had heard of this until relatively recently, but it is a defense that's out there. and the courts are starting to discuss it, and they're starting to rule on it. So be aware of it. And then finally, I want to talk to you guys about right to counsel. And I apologize because what I didn't do is I didn't change the slides. So let me go ahead and do that. Oh, we're on the right side, right to counsel. 2025, many of you remember from last year, Los Angeles County stated that they are funding their right to counsel program. And their goal is to have it throughout every city in Los Angeles by 2030. So we're 5 years away from that. Right now, it's got funding, permanent funding for 1 year, and they're going to see how it pans out. So right now, it only applies to properties that are located within unincorporated Los Angeles. Like I said, by 2030, they want to have it in every single courthouse throughout the county for every single city. Let me tell you what I've seen with right to counsel. It is going to be a nightmare for the landlords. We are, ever since COVID kind of came to an end, we have seen an explosion in tenants' rights attorneys. Many law firms who have never practiced tenants' rights out there ever before, but have been in existence for a long time, are now starting to jump in to the tenants' defense area of law. Why are they doing that? Because this is a gravy train for them. You guys pay for everything, and it ain't cheap, but they pay for nothing. Okay. And right to counsel, you should understand it. You can look it up, figure out what it means, but I'll give you the highlights. The highlights are essentially it's a play on the United States Constitution that says anybody who's being convicted or charged with a crime has a right to an attorney. Well, this movement is taking place across the country that says, well, anybody who's about to lose their housing or be evicted has a right to an attorney. And the way they sell this, and the reason it's spreading, the way they sell this to the cities and counties is it's much cheaper for the city or county to fund attorneys through taxes than it is to pay for homelessness. And by the way, it's an easier sell to do it through taxes to provide these attorneys than it is. And it's cheaper, allegedly cheaper, on top of it. I imagine many of you on the call have seen the reports that came out last week or the week before, toward the end of the year, where Governor Newsom was lit up when he was asked the question, with the billions of dollars that you've poured into homelessness, why isn't it working? What's going on? Because there's a lot of, I won't call it corruption, but there's a lot of, what do you say, fluff to go around for everybody. And so you're looking at the same, it's a boondoggle is what we would call it. It's the same thing is going to play out with this right to counsel. These attorneys, these law firms that are jumping on this bandwagon are looking at this saying, this is a gravy train. They're going to pay me $200 an hour, and I'm going to fight like hell to keep these tenants in there. And in light of all of these hyper technical requirements that have been either in place or put on steroids over the last 5 years, there's a lot that these firms can argue, and there's a lot of ways to drive the fees up on these evictions. And they're doing it. Like I said, there's an explosion in law firms doing this and defending the tenants. Pre-COVID, probably 50% of tenants, maybe less, maybe 45% of tenants in LA didn't even file an answer. Now it's probably maybe closer to 10% of the tenants don't file an answer. So again, the last expanding and emerging trend I've got here is this right to counsel movement. So that was a lot. Let's jump on to, well, we've talked about it here. Let's go through the notice requirements. And by the way, I just called the county yesterday. They said they do not have their notice drafted yet, and it is not required yet. I wouldn't trust them at all. If you've got a property in unincorporated LA, and let me clarify, I wouldn't trust them not because they're evil, but because you've got, people answering the phone that oftentimes don't know what they're talking about. So there are notice requirements. If you've got a property in unincorporated LA, you've got to use this county drafted form. They did say that they don't have it yet. I checked their website and couldn't find it, but it's got to be provided upon service of any termination notice. And it's also got to be provided at the lease in another, if there's a lease in another language. So you've got to give that notice in the other language as well. And I apologize, I muddled through that. What I meant to say was, if your lease was negotiated in another language, you have to provide that notice upon the service of a termination notice, but you're going to have to provide it in both English and that other language. I hope that clarified. And it's got to be posted in an accessible area of your property and in the on-site manager office if you have one. So again, look into this right to counsel through the county. For those of you who don't have property in unincorporated LA, just wait, your turn will come. I would start looking into this anyway, right away. All right, strategies for successful evictions. Can you do them? Yeah, you can. It's harder than hell. Excuse my crass language, but there's just no way to describe it these days. But how do I define a successful eviction? It's one that never occurred. So how do you do that? Well, you've got to stay current with these evolving laws. You've got to take these classes, take the seminars, attend every class and seminar you can. You've got to go deeper in your screening techniques and processes. And with that, I will say you've got to now mesh your screening techniques with these new laws and evolved laws. Um, that if you just do one without the other, you're asking for a problem. These screening limitations that we talked about today, and there were some last year as well, they're going to get you in trouble. But you do need to be diligent with your screening to keep these problem tenants out. You've got to have more stringent rental criteria. You've got to revise your policies. Remember, we just talked about in your screening now, you have to decide. Are we going to go with the first qualified, first accepted, or are we going to not charge fees and sit and wait a few months, which in my opinion may be better. It might be better to have a vacant unit for a few months than the cost of an eviction. So you've got to revise your policies and your procedures now with all of these new laws in place. Success in evictions, yeah, it happens, but let me tell you, it comes for virtually every property. It either is or will be governed by some sort of a just cause ordinance now. You may be lucky and have one that's exempt, like a single family home somewhere, but for the vast majority of rental property owners out there, your properties are either now or going to be covered by some just cause ordinance. And let me explain briefly what many landlords seem to not understand. When I write here strict compliance with legal administrative requirements first, to clarify what I mean strict compliance. For example, if your property's in under RSO, LA RSO, you've got to not only pay your registration fee, you've got to get a copy of the registration and post it. You've got to serve a copy of that registration before you're even allowed to demand rent. And it isn't a question of, hey, I paid my registration fee, so I'm registered, so I can demand rent now. Nope, you will lose that case. It is a question of strict compliance. And so I've said this many, many times over the last several years at least. If you have a property that's governed by one of these ordinances, I would encourage you every single year, download the ordinance, read it, understand it. If you have questions, set an appointment with a landlord tenant attorney who's competent to decipher what the ordinance means. But if you are not complying, strict compliance, if every T isn't crossed and every I isn't dotted with these ordinances, you're going to lose your evictions. Is it possible to comply? Absolutely. So what are the strategies for success? Stay positive. You can win, but it takes work. And it takes work on your end as well. You can't just throw it off and say, well, I think I've complied. No, you have to make sure that you've complied. Like I said here, work with a landlord attorney, be strategic and patient. If it takes more time than you're used to, understand that that's the system at work right now. Prepare in advance for your evictions. Digitize all of your tenant files. We're moving in that direction anyway. I would assume, maybe I'm wrong, but I would assume most law firms are going towards digitization. We are now digital. All landlords, I encourage you to digitize your files. What does that mean? For your property and every single tenant, create a folder on your computer. If you need backups, you get backups. Obviously, you don't want to lose this stuff, but for your building, you should have copies of all your permits, your certificate of occupancy, if it has one. Any violations that have been written on your property, you should have a copy of it, as well as the write-off. Anything you can get about your property, your receipts for work you've done, for damages, anything should be digitized. For your tenants, every single communication should be digitized. Every notice should be digitized. Your lease should be digitized. Like I said, technology and time march on. We are moving away from paper files in everywhere you look, every industry, and it will help you in an eviction or any sort of lawsuit. How? It'll cut the time down. In evictions, for example, discovery is required to be responded to within 5 days. Can you imagine if I tell you, hey, by the way, I need about 50 or 60 documents from you? How easy would it be if you just emailed those to me? It'd take you 5 minutes versus 3 to 4 days for you to gather all these documents, and some you probably won't even have. So, like I said, digitize everything, prepare for discovery in advance, and assume you're going to get hit with discovery with this army of attorneys that have popped up, and document every single thing throughout your relationship now. And I mean everything, one way or another, document it. And if you need guidance on that, happy to help. Today's not the day. I don't have time to go into it, but I'm happy to talk about that at some point. All right, with that, that was a lot of information. And I think I've covered everything that I needed to cover. Those are the new laws and the emerging trends for 2025. I hope it was helpful. And if we've got some questions, I've got a little bit of time that I can answer them.
Great. Thank you so much, Mike, for that. Super comprehensive. And as we expected, there were things in there that other people may have missed. And so that was absolutely great. On that last point there, we do have the property management software that gives you a place to upload documents, pictures, to digitize, to have a contact history section that you can download as a report. So that's all there. And then even with the rent reporting, for those of you that are going to have to be doing that, there's rent reporting. You don't pay for it. Actually, the renter, they pay for it, but actually the first 100 or so renters that are onboarded are going to be free anyway, but they're only going to be paying $1, so that's not something you have to pay. Really interesting with rent reporting. The way SB 1157 is written for Section 8 rent reporting from a couple years ago, and then the way the new one's written, there's two different documents that that the attorney that we work with realized that we have to have. So both of those are up in the forms A and B, but really, if you're offering rent reporting, you have to have a way to do that. And so our property management software will do that for you. And yeah, there's tons of questions here, so we'll just try to jump into them. And
For 1 second, I'm going to shut the video down just for 1 second, but I'm listening.
okay. All right. So Heather, can a landlord opt to not charge a screening fee if no payment is taken? Is the landlord still required to offer the credit report or the AOA ABCD report to the prospect? So you covered that.
Yeah, my reading of the law as it is you've still got to provide a copy of the report, even if whether you're taking the fees or not.
Mhm. That's
It's
right.
all tenant.
And you covered just laws, California ordinance, but there's also ICRA, which under certain
There is.
circumstances you need to give them that copy in 3 days. So I would just say, if you want to just cover all your bases, like sometimes you don't know that they fall under this certain category in ICRA where you have to give it in 3 days. Like they may not disclose that they're homeless, but if they're homeless, you're supposed to give it to them within 3 days, I believe. So it's just give it to them in 3 days, even before you've made the decision. It's okay to give it to them. And anyway,
It's mandatory. Just give it to
yeah,
them.
right. Yeah. I mean, it's 7 or 3. What's the difference? You're going to have to hit the send button on your email anyway.
Right.
So, okay. Subhash, what is allowable rent increase for the city of Concord? So Concord is Northern California. Next month, February 19th, Attorney Richard Beckham will be giving a legislative update at the AOA, the Bay Area Landlording Power Conference in Santa Clara. Mr. Beckham is in Alameda. He serves like a 7-county area out there, and he knows Concord for sure. So you can ask him, or just call him up. Look him up. Go to aoausa.com. Look him up. Type in attorney and look up Beckman, Feller, and Chang, and just give him a call if you need to know it today. All right, Steve, is there any way to appeal the rent increase limits if expenses have increased dramatically?
So in most cities, there is. They have what's called a reasonable return policy that says all landlords, and I believe this came from the Supreme Court, all landlords are entitled to a reasonable return. Unfortunately, I have never seen a single reasonable return request granted, but I
Hmm.
don't that I'm not trying to tell you not to do it. You should do it. Figure out what the city, you didn't mention the city you're in, but figure out what the city, whether the city has that as an available appeal and what the requirements are. Create a spreadsheet, go in and show the city that you're not making a reasonable rate of return. And one word of caution on that, it's important that landlords understand that cities aren't out there advocating for landlord rights at all. Most cities are out there advocating for tenants' rights. And when they create their metrics that says, okay, this is how we will determine whether the landlord is receiving a reasonable return, they do take into consideration the fact that you're obtaining equity. So right now, properties may be decreasing in value. That's something you would want to bring up in that hearing. But for a long time, they were, the equity was building, and the city was taking that into consideration, saying that's your return right there. So, like I said, keep it in mind. If you can demonstrate you've lost equity in your property and that you're going into the hole as a result of CPI and stuff like that, absolutely apply for it.
All right. Trevor, West Hollywood and LA City RSO, with the new deposit requirements being no more than 1 month, can the deposit go up with rent increases? I think he meant more than deposit being more than 1 year. I think he meant.
No, I think what he's trying to say is there's a limitation on security deposits. The maximum you can ask is 1 year.
1 month. Right.
Right,
Yeah.
right.
Okay.
I'm sorry, I just said 1 year. 1 month.
Yeah.
Maximum you can ask for is 1 month. Now, there's a couple exceptions, but for the most part, it's 1 month. Um, I would say to you that you have to check your specific ordinances. Some of them prohibit it. So you're stuck with that 1 month. So, it's kind of funny if you think about this for a second. These ordinances are all alleged to be to protect the tenant. And what I can tell you is every time they enact one of these, the landlords that start scrambling. Oh my gosh, I was trying to help all my tenants. I kept my rents low. I never asked for security deposits, or I never increased the security deposit. Every single ordinance that passes does nothing but damage the upcoming tenancies because landlords have to shift gears now. Now everybody's got to ask for a month. Nobody's going to say, "Oh, I'll only take a half month, depending on your credit, etc." Everybody's asking for a month, and every property that is able to every year on a rent increase should be increasing the security deposit simultaneously.
All right. In the chat, Lauren, we have properties in Monterey County. Salinas just acted a rent stabilization in the city there. Do you have any insight on it?
I don't, because that's Northern California, and I really focus in Southern California.
Right. And Lauren, email us, and we have other members that are there, and there was some political action things that we did, and I think I could probably connect you with someone who would know a good attorney. So email membership@aoausa.com if you're a member, and hopefully we can connect you. Carlos, hi Mike. I want to know if we can charge a tenant for a 3-day pay or quit. If so, what forms or verbiage need to be for a property in LA County? So
Yeah, we covered that.
yeah,
No, the new law prohibits you. We used to be able to. We did it all the
right,
time. It was part of the lease. But
right.
the new law actually prohibits charging tenants fees for either termination notices or because they pay their rent or security deposit with a check.
Right. And at the very beginning, when I went over how the leases changed and why you need to use the 2025 one, that was one of those things that was in there. Okay, Chris, does AB 2493 include third-party screening fees not directly charged by the landlord?
2493. Hang on a second.
So
I don't want
we have the two
application screening.
options on, yeah. So the
Yes.
screening fee.
So the law used to allow you to recover both hard and soft costs, and I guess that would be considered a soft cost. Hard cost is right out of your pocket. Now I don't believe it. I think it's going to include those third party fees. So in other words, if you're paying AOA to do your screening, yeah, that would be a part that would fall under this law.
So
So
like
you would have,
next, yeah,
go
so
ahead.
like in the next month or two, we're going to have software where the tenant pays for it instead of the owner. So the owner's not
Fantastic.
collecting an application fee. They're not going to be able to get that renter's not, or applicant's not going to be able to get that money back from AOA, correct? in
Not
that
that I'm
kind of
aware of,
instance.
because this law
Right.
specifically addresses landlords.
Right. Yeah. So to answer your question, like the AOA software that's coming out in a couple months where the tenant pays or whatever software you may be using, they won't have to, that law
Right?
will not
That'll be a
apply.
non-issue at that point.
Right.
But you remember when you're handing out your screening policies or your rental criteria, you might want to include that in your screening criteria that, hey, the tenant goes to this link and the tenant's responsible for any fees that might be associated.
Right. And last week we covered, setting your rental criteria, even if you go with the option where you're returning the money or not taking the fee, it's still just a best practice to have it because people are going to self-select out and just save you time anyway.
Yep.
Okay, Kristen, is there a form to have tenant to agree to email photos, etc., like before
There is no,
moving?
I don't know if AOA has created form. The state hasn't created a form. They just said you can agree to it, and it should be it has to be in writing. So I would imagine it'll be one of your pre-lease up documents that AOA will create.
Yeah, okay, there we
Just
go. We got
volunteered AOA for that.
yeah. Thank you. One more one more thing to
One
do,
more
right?
form.
Yeah, well, here we are, right? Bill, do you have a tenant? Okay, if you have a tenant that has been living in the unit for several years, do you have to report rent to credit reporting agency?
Yes. So it's for all tenants now. There's the two different dates. I gave you the dates. I forget what they were now. I know one
April 1st. It's April 1st either way. Yeah.
April 1st, you've got to start reporting that,
Yeah.
regardless of how long they've lived there.
Okay. Kristen, SB 1103, are 3-day notices included in the prohibition?
Can I back up for a second?
Sure.
Let me rephrase what I just said. You've got to give the tenant the offer. You
Offer
don't
before.
necessarily have to report it, but you've got to give them that document that Jeff's got that is the
Mhm.
offer that they can opt into the program.
Right, but you should have a program behind the
You
offer.
should,
Like
absolutely.
you need to have a platform behind it.
Right,
And but yeah, just offer it and then you can get that thing going and yeah, it'll be great. And let them pay for it. You don't have to pay
right.
for it. Okay. Okay, so Kristen, she said SB 1103. I'm not sure if that's the right number or not, but are 3-day notices included in the prohibition?
1103 was commercial tenancies.
Oh, commercial. Okay.
Yeah, so let me just real quick. No, what I talked about with that one was that you had to give rent increase notices. I'm not sure what she means by 3-day notices.
Yeah, maybe it was 611. I'm kind of thinking maybe she's thinking of 611 about not being able to charge the $50 fee. Like,
Notice fees, yeah, that one you're not, yes, 3-day notice, all termination notices. You cannot charge them fees for that.
okay. Sun Tonk. Okay, will AOA provide a template for company policies and procedures relating to FCRA compliance? If you want one, I have. Yeah, one of our providers has something. If you want that, email me directly, jeff@aoausa.com, and I'll shoot that over to you. There's one for what they're talking about is there's FCRA stuff, but then also the housing puts out those guidelines and they say you need to have these things in place. And it's their suggestion, but if you're in a lawsuit, you better have all this stuff in that suggestion done. So yeah, that would be smart. And yeah, we do have something, but it's not a form that's up on the website. Email me directly on that and I'll get it to you. And I doubt there'll be very many people that ask for that, but okay. Okay, if my property in LA falls under rent stabilization ordinance, will a garage conversion ADU also be subject to the rent stabilization ordinance?
So I'm assuming you're talking about RSO, the original RSO.
Yeah.
If your garage, that's a good question. The way the RSO is written, it's based on the certificate of occupancy. So if you've got a brand new certificate of occupancy, I would imagine the ADU is not covered by that, but be careful because it will be covered by the city's other just cause ordinance.
Yeah.
without
The
a
tenant
doubt.
protection one.
Right.
Yeah, yeah, that makes sense. Okay. Seville property management, Berkeley, Oakland question. Can a fee be added? And so again, Berkeley, Oakland, please call Rich Beckman or just look in the magazine. There's attorneys in there. If you look at the contractors and vendors, there's attorneys in there that will take your call and they could help you with that. And yeah, so sorry about that, guys. And definitely go to the power conference. It's going to be at the convention center there. Okay, Steve, how do I appeal to California to increase rents? You kind of answered that one already, but it's a how to. So how would you actually do that?
Appeal to the state of California to increase rents.
Yes.
So it sounds
They
like
had
he's talking about under the Tenant Protection Act.
yeah,
Um,
okay, so no, he's not. It's let me read it all. The above the allowed rent limits if my expenses have increased dramatically. It's in Big Bear Lake. They had two FEMA declared disasters in the past 24 months. So,
Under the state, the Tenant Protection Act, I am not, off the top of my head, I'm not aware of any procedure that the state has provided. It's the only time I'm aware of those is under the locals like LA, Beverly Hills, Santa Monica. In those, you can file a petition. I don't recall ever reading about a method with under the Tenant Protection Act.
okay. All right. Does landlord have to attempt 3 times to get a live tenant or person before posting on the tenant door a 3-day notice?
No. So let me rephrase the question. If you go to the door and you knock, ideally you're going to want to serve them a 3-day notice personally. But the question is, do I have to go back 3 times? No. If they don't answer the door, post a copy on the door. Be sure you take a picture and mail the copy the same day. Your time will not start ticking until you mail that copy. And mailing the copy doesn't increase the time as long as you do it the same day. But you don't have to make 3 attempts.
Okay, so Kristen, with AB 2898, LARSO or state, Section 8, do we have to unbundle parking now?
So first of all, let's talk about that. Those are only buildings with a certificate of occupancy issued after January 1st, 2025. So the odds are you're not covered unless your building just got its C of O in the last week. So I wouldn't worry about that.
All right, Sharon.
If your building did get its C of O in the last week, yeah, and you're covered by that, yes, you're going to have to unbundle now.
Right, but then just because they're under RSO, they're probably impossible to be.
They won't be under RSO if they just got their C of O.
Right,
Right.
exactly. All right, Thelma, I'm in the process of offering cash for keys to a tenant due to a notice from the city of Bell Gardens of the unit being substandard. Can I issue an eviction if they don't accept the cash for keys?
So Bell Gardens does have a just cause ordinance, and there are specific requirements that you're going to have to jump through to do that. You have no, yes, you can do the eviction because what you're going to want to do is you're going to want to comply with all the requirements, strict compliance, do it all. And for those of you who like to make phone calls to housing departments, don't bother. Go down there and set an appointment and talk to somebody at the counter. Say, this is what I've got. I'm trying to comply. First, when they see you're trying to comply, they oftentimes offer exemption. I'm sorry, not exemptions, extensions before your
Hmm.
compliance date because they say, hey, they're working with us. Two, cross all your T's, dot your I's, do it right. If the tenant refuses it or rejects it, then you're going to be able to file your eviction because you've done everything you're supposed to do. But keep the money in an escrow account. Don't put it in your own account.
So the unit being substandard, does that mean it's not up to building code or what is that?
Yeah, it
Isn't that
means
what
there's
that
some sort
means?
of a violation of a health and safety standard.
Right, there you
There's a
go.
lot of them. I mean, you can have a substandard building for a million different reasons.
Hmm. Okay, Frank, should you require both married tenant to qualify on the credit report, even though one is not working, like a stay-at-home mom?
Yes, you should require an application from every adult who's going to be named and sign that lease. Now, how do you do the numbers when one's not working? when you're doing your, your rent to gross income multiplier, you do it on the whole household. You don't do that individually. You're not going to disqualify the wife merely because she doesn't have a job. You're going to look at the bigger picture. But yes, I would encourage you to get backgrounds and the whole screening process, I should say, on each of them.
All right. On YouTube, Andrea, how does the tenant response time after a UD has been filed change if you've included a proclaim to right of possession? Does it change with the new laws?
So she's asking about prejudgment claims of right to possession, and those
Mhm.
are those are not named tenants. And no, that wasn't impacted at all. Essentially, it's only on personal service that was impacted, and that obviously a prejudgment claim of right to possession doesn't come into play with a personal service on a named tenant. You're not going to personally serve somebody you don't know is there. So no, that is not impacted at all by that law.
Okay, good question by Sharon Fudge here. When you mention County of Los Angeles, do you mean unincorporated areas or do
Yes.
you mean all cities within the
No,
county?
I apologize. I tried to say that a couple times. I'm only talking about properties located in unincorporated areas of Los Angeles.
All right, Daniel, regarding LA anti-harassment, can we require a social security number from new applicants?
Um, I don't recall the anti-harassment statute prohibiting that. So you might be surprised to find out I haven't memorized every word in every one of these ordinances, but I don't recall there being a prohibition against requesting a social security number in LA.
From an applicant, I don't think I mean I read it, but and I don't recall anything in there either. But I don't think from an applicant, I don't think it's an issue. If you're trying to ask that from an existing tenant, maybe
That could
I
be an
mean
issue.
just
Yeah,
about anything is going to be
yeah.
considered
Let's
harassment.
clarify. Maybe I misunderstood the question, but Jeff's exactly right. If you're talking about applicants, I don't think that's an issue. If you're asking an existing tenant with an existing tenancy to provide social security numbers, yeah, you're going to run into a problem with that, especially if they don't have them.
But that was about an applicant. So I just want
Okay.
when
Yeah,
people
applicant,
listen,
don't see a
yeah,
problem.
right. Okay, chat in the chat. Oh no, it's yeah, in the chat we have Ashley for landlords reporting rent payments to credit agencies. Once the tenant completes the form, where does the landlord go to report? And so really this is done through third-party software. So like for us, we have property management software that's separate from what you have with your AOA member account. And so from that platform, or in that platform, you enter the leases, and basically the program generates a balance, and then you either go in there and record the payment, or they make an online payment, and then we take the data and we put that in a file that is compatible with TransUnion, and that's how that one works.
Jeff, does AOA offer as a separate service the ability to report this stuff if you don't have the management software?
Today we don't, but I'm thinking that we probably should. And so like, yeah, I'm thinking we should, but we don't have it today.
Okay.
So what we have today is just the through our property management software.
Sounds
And
like a
now,
new cottage industry is going to pop up.
right, and I'm thinking of offering like that white glove kind of service where people could just like write it out and fax it, because not everybody's good with all different kinds of things. But there's still, this thing is you have to offer it to them. Then they have to give you something signed, right? That offer is signed. And then we have to verify their identity. So we're going to need like a copy of their driver's license and be able to verify who they really are, every single renter. So there's a lot involved. And when it's done through property management software, the tenant's more interacting with the software, and it's just easier on the owner. So
Hmm.
anyway, all right. So thank you, Ashley. Sunshine 25 rentals. If your rental agreement says the rent is due on the first, do you have to report the rent as paid on time? If it's paid on the second, what constitute an on-time payment? And with that one, it's pretty interesting. Do you
That's a
want to
great
say something
question.
on this
Go
or?
ahead. I want to hear you out, but that's a good question.
Oh, you're frozen. Maybe. Okay, there you go. You want to say something there?
No. I want to hear you out. I just said that's a great question.
Yeah. Oh, internet connection's not great. Can we plug me back in, maybe? Um, yeah, so the way that it works, that whole on time thing is kind of a misnomer. Like if they get the rent in, it's basically going into the file. And so it's not going to show late payments, even though you would like it to. So positive rent history, it's not that. And really the way that law was written, it's you can offer positive unless it's section 8, then you can offer positive and negative rent payment history. So it depends on who the renter is, but most of the time it's just going to show that they paid. So it's not going to show that they paid late every month, which is kind of a bummer. uh, Bummer for us as owners, but you know,
When you
that's how
say
they
it's
do it.
not, when you say it's not going to show, are you talking about your software?
No, meaning the file that TransUnion takes from us,
Uh-huh.
what they put up on that credit line in that renter's credit report, it's not going to show anything late there. They're not going to show anything late. Like, yeah, what we report is that it was paid on whatever day that it was actually paid on, but they won't show a late payment. They'll just show that a payment was made.
Is there a way to structure it so that if it was not, and I want to get to her question because that's going to be defined by the lease, but if it was not paid on time. So let's just use a very simple example. Rent's due on the first, there's no grace period, no late fees. Due on the first in advance. Tenant pays on the second. That would be delinquent under most leases. In that situation, would you simply just not report for that month?
If you didn't report it in our software, then we would report it as not being paid, but then they have the right to dispute whatever reporting. So then the renter's going to come and say, no, I paid. Here's my receipt or here's my payment confirmation. And then we would have to put it up there anyway.
Hmm. Well, you could dispute. You paid, but because that's what happens when people dispute things on their credit report. They file their dispute, it goes to the creditor, and the creditor has the right to make a statement. Yes, you paid, but you didn't pay timely.
Right. But the way that TransUnion is operating,
Uh-huh.
they're not, yeah, their policy is to not report late. They're
Got it.
just
Okay.
whether it's paid or not. So
Uh-huh. Okay.
it's more a deal with TransUnion than it is with and then Experience. TransUnion, at least they take positive and negative, where Experian, they don't even take the negative period. So two different
Hmm.
companies, they operate differently, they have their own policies. It
Right.
doesn't match up the way that we wish it would, right? So
So my suggestion for the person who asked the question and everybody else on the line is if your rent is due on the first and you don't have a grace period, and even that we could unpack, but if you don't have a grace period, you should be serving 3-day pay or quits on the second, because at that point, unless they pay the full amount, you don't have to accept it. So that would give you a little bit of I don't want to call it wiggle room, but get your 3-day notice out right away as soon as you can. And this way, if they don't offer you the full amount if they offer the full amount within the 3 days, you have to take it, and I guess that's going to get counted as a positive rental payment. If they don't offer you the full amount within the 3 days, you don't have to take it. It's not going to get reported, and it won't show up.
and then the whole thing here, remember that if they've opted in, the chances that they're going to pay their rent on time is
That's
like
true. Yeah, that's pretty
it's
slim.
it's out of the roof. Like your probability of getting the rent from them just went up like
Right.
dramatically. If they've
Yeah.
opted in, they're signaling to you that yes, this is what
I've
I
got this
want.
covered.
Right. So, and if they don't pay it, they know they're out for 6 months too. So all those laws are, all that's in there, and it's not great, but it's really it's going to benefit. I think it's going to be any landlord that signs up for it. I think they're going to see more on time payments. They're going to see more full payments. Yeah, so I think it's going to be a benefit. It's going to be a win-win. It's going to be a win for the owner. Going to be a win for the renter. Okay, does your book cover California's 2025 laws? Did you mention a book?
No.
I wonder what they meant. So, that one we're just going to skip past it. Tenant, okay, tenant owes 30,000 from pandemic. He pays current rent, but what about the balance? Can I still collect?
30,000 from the pandemic. Let me say right off the bat, you're running into a statute of limitations issue. So you have 4 years to file a complaint on a written contract, and I hope you're in the written contract. And every day that ticks by, you're losing money. So the short answer is, as long as the debt came due in the last 4 years, go file. In LA, a lot of that debt did come due in the last 4 years
Mhm.
because it had been deferred until February of 2024, I believe. So, was it 24? Yeah, I believe so. So, yeah, I mean, it'll depend on when it came due, but you can collect at least some of it. Anything going back 4 years.
Right. And we have a debt collection service, and I think they go back 3 years. So 3 years from the time that it was due. So you can do that. Full disclosure, AOA, it's 50-50. You get 50% of whatever they recover unless it goes through like legal, and then you get 40%. No, you get 60%, then you get 50. And you get 50. The company that's doing the debt collection that we're using, they get 45%, AOA gets 5. So there's a little benefit for AOA. You still get the same amount either way, but we just share a little bit of what the collection company is getting. And so just that's a reason to do it with us. But we've looked at different companies and we think they're the best, but there's a lot of effective companies out there that can do debt collections as well. But yeah, you got to get on that.
Jeff, I have a question for you. Ever since it was sometime the beginning of COVID, Governor Newsom changed the metrics that allowed anybody to implement a wage garnishment, and it really pushed the amount of money that the person had to make up dramatically. Are you still seeing success with these debt collectors?
Yeah, we are, but it's not a high probability thing. Once they've moved out and they owe
Yeah,
money, like
yeah.
it's not high probability that you get it back. But yeah, we still are seeing people get money, recovery money for
Good.
sure.
Yeah. Okay.
Mhm. So Sheila okay, how much I want to respect your time. We're past 12.
Yeah.
So
I could take one more question.
okay, we'll do one more. Suzette, we have current month to month residents. Oh, can we have current month to month residents sign a new lease to make sure all the new policies are covered?
Well, first of all, I don't know what city you're in.
So
Because
she's LA. She's in LA.
Okay, so you can ask, but I would be cautious because of that anti-tenant harassment statute. Like I said, they really expanded that, and it's almost like if you talk to your tenant, you're going to be accused of harassment. So you can ask, but you can't force it.
Okay.
And if
And
you
also,
ask, I would suggest you ask with a witness there who can, be prepared to testify if necessary, that you asked very nicely, very politely, there was no pressure.
right. And then also just think about like for the lease agreement that's been signed and all of a sudden there's 611 has taken effect now where you can't charge that $50. That part in your lease is basically just it's worthless
Boy,
now in
yeah,
your existing lease. Just moving forward, don't charge that $50.
yeah.
That's listed there in the old AOA lease. So
That's a
just
great point. I
basically,
probably should have pointed that out. Just to
mhm,
reiterate that, it doesn't matter if you've got a lease that says you're entitled to charge them $50 for a 3-day pay or quit, or any of the laws I talked about. As of now, those are the laws. Just stop doing it.
right. Hey, thank you so much, man. I really appreciate you,
You're very
Mike.
welcome.
And it's just always such quality. I really am looking forward to the in-person seminars that we're doing. You got
We
one
will
in
see you
Buena Park
shortly.
coming up a little bit later this month, and then also in Long Beach, I believe, two places. And so you guys can meet them in person and ask more questions. And anyway, apologies that we couldn't get through everything, but thank you everybody for your time. Please share this with someone who needs it because people need this. Give it a like and let's get the word out so that because yeah, just because if you don't know this stuff, I mean, it could cost you a whole lot of
Right.
money in so many different ways. So thank you, everybody.
All right. Thanks, Jeff.
Okay, take care. Bye bye.